Hello and welcome. A certified ETA Form 9035 Labor Condition Application, or LCA, is a prerequisite for an H-1B petition. The LCA must be certified by the Department of Labor before the H-1B petition is submitted to USCIS. The employer must also document compliance with the LCA requirements in a public access file. In this presentation, we'll provide an overview of the H-1B LCA along with the filing procedures and compliance requirements. Let's get started. The LCA, what is it? The LCA contains basic wage and location information about the proposed H-1B employment. The LCA contains the rate of pay, period of employment, and work location. It also contains 4 standard attestations that the employer must make. The LCA must be certified by the DOL and submitted with the Form I-129 in order for the H-1B petition to be approved by USCIS. Let's look at a case scenario to understand this better. Company A wishes to hire Santosh, who is currently working on an H-1B visa for Company B. They extend an offer to Santosh, who accepts and returns the signed offer to Company A. Company A completes and submits the LCA through the DOL flag portal. Because they want Santosh to start as soon as possible, they submit the H-1B petition without waiting for the LCA to be certified. Santosh starts working for Company A the day after the H-1B petition is filed. Will he run into any problems in this situation? Yes. The H-1B petition must include a certified LCA. USCIS will either reject the petition for lack of a certified LCA or request the certified LCA through a request for evidence. Ultimately, USCIS will deny this H-1B petition because there was no certified LCA as of the date the H-1B petition was filed with USCIS. This will leave Santosh out of status and he may need to leave the country. Now that we have seen how critical an LCA is, let's look at how to file an LCA. Filing the labor condition application. The H-1B employer must generally file an ETA Form 9035 electronically through DOL's flag portal. Or a petitioner can file an LCA by mail. However, he or she must be able to show that they have a physical disability or lack of access to the internet that prevents the employer from filing the form electronically. The employer must first obtain pre-approval from the Department of Labor to file an LCA by mail. At the present time, it takes the DOL about 5 to 7 days to certify an e-filed LCA. One very important thing to remember is with H-1B work location changes. Each LCA is limited to one job title with specified job duties for the specific location or locations listed on that LCA, and they can be used for more than one H-1B petition. If the employer places an H-1B employee outside the area of the work location or work locations listed on the LCA and the H-1B petition, the employer is required to file a new LCA and an amended I-129 petition with USCIS. Now let's talk about attestations made on the LCA. By signing and filing the LCA for an H-1B petition, an employer makes 4 attestations or promises. First, the employer will provide the H-1B employee the same benefits offered to U.S. workers and pay the H-1B employee the higher of the actual wage paid to others by the employer who have similar experience and qualifications for that specific job in the company, or the prevailing wage for the occupation in the area of employment. The employer will provide the H-1B employee working conditions that will not adversely affect the working conditions of workers similarly employed in the area. Working conditions commonly refer to matters including hours, shifts, vacation, and other fringe benefits. 3, there is no strike or labor dispute at the place of employment in the same occupation listed on the LCA. And 4, the employer has provided a notice of this filing to the union bargaining representative, if applicable, or if there's no bargaining representative or union, directly to the workers by posting a notice of filing in at least 2 conspicuous locations at the place of employment for a period of no less than 10 business days. The H-1B employer has also been given a copy of the LCA. It's important to remember that violations of the LCA attestations can expose an H-1B employer to civil fines, barring of the employer from obtaining further visas for a period of sometimes from 1 to 3 years, and makes the employer liable for payment of back wages. The public access file. The employer must make available for public examination a copy of the certified LCA and necessary supporting documentation regarding the H-1B worker or workers and other similarly situated employees at its office in what's called a public access file. The PAF documents compliance in each H-1B case. The PAF must include the following: a copy of the certified LCA with the employer's original signature and LCA cover pages, documentation of the wage to be paid to the H-1B employee, explanation of the system used to determine the actual wage paid, documentation regarding the prevailing wage and the wage source, a copy of the notice to the union if applicable or workers, the notice of filing, summary of benefits plan offered to the H-1B employee showing that it is the same or similar to that offered to similarly employed U.S. workers, and an explanation for how any variations are determined. A copy of the certified LCA with signatures of the H-1B employee as proof he or she received the copy. Documentation regarding any adjustment to the wage, for example, an annual raise or cost of living increase. And if the employer is H-1B dependent or has been found to be a willful violator of the LCA regulations, proof of efforts to recruit U.S. workers. And finally, after the creation of the PAF, where the employer undergoes a change in corporate structure and does not choose to file an amended petition for each H-1B it acquires, a sworn statement from the new company that it accepts all obligations under the LCAs filed by the predecessor employer, and a list of affected LCAs. The PAF must be maintained and be available for public inspection for at least 1 year beyond the dates of employment on the LCA, or for at least a year from the withdrawal of the LCA. Which takes us to withdrawing an LCA. In order to limit potential liability, including the payment of back wages, the employer may need to withdraw the certified LCA if the H-1B employee's employment is terminated, as long as no other H-1B workers are employed at the place of employment pursuant to the same LCA, and making sure no investigation has been commenced regarding the particular application by the Department of Labor. The LCA is an integral part of the H-1B filing. Compliance with the complex LCA regulations is critical for all employers who employ H-1B workers. Combining our legal knowledge with extensive experience representing companies undergoing DOL investigations, VisaPro provides clients with the tools necessary to run a successful H-1B process. VisaPro can conduct audits of H-1B LCA and public access file compliance, assisting H-1B employers document their good faith efforts to comply with all regulations. If you have questions regarding the LCA or would like to discuss compliance issues specific to your company, please call 202-787-1944 or send an email to rose.kelly@visapro.com. Our experienced immigration attorneys will be happy to guide you. With that, we come to the end of this presentation. If you wish to continue to receive updates on these topics and other U.S. immigration matters, subscribe to our newsletter on our website at www.visapro.com. The specific link is on the slide. Thank you and have a wonderful day.